front lines of law, leadership, and public service. From the courtroom to the classroom, Attorney Karen Jimeno brings sharp legal insight, academic excellence, and a voice that has guided national conversations. Attorney Mike Toledo, a seasoned public affairs strategist and legal mind with years in media, corporate leadership, and government reform. Together, they bring law to life with experience, integrity, and the courage to ask hard questions. Two minds shaped by the law. Two voices trusted in and out of the courtroom. This is ABOGADO.
Good evening. Welcome to ABOGADO, where we examine the questions that test both our laws and our values. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight, we open with an issue that challenges how we define truth, fairness, and family. Let's take a closer look.
In inheritance disputes, the law gives birth records a special weight. A birth certificate is a public document, presumed true unless overturned by strong evidence. But what if other relatives question that truth? Should the courts allow DNA testing to settle doubts, even if it means challenging what official records already say? Some argue DNA is the ultimate tool for finding the truth. And fairness in inheritance demands that no one be disinherited because of an inaccurate record. Others warn that opening the door to DNA tests risks destabilizing families, undermining children's rights, and weakening trust in our civil registry system. This is not just a question of science versus law. It is a question of justice versus certainty. Should courts allow DNA testing in inheritance disputes, despite the presumption of truth in birth records?
Joining us tonight is Attorney Aliakhbar Jumrani, a litigator and law professor who has taught and practiced extensively in procedural and family law.
He has worked with the Court of Appeals and the Government Service Insurance System and has been teaching in law schools and bar review centers since 2005. He graduated cum laude from Silliman University College of Law and hails from Zamboanga City. Good evening, Attorney Al, and welcome to ABOGADO.
Thank you very much. Good evening, Attorney Mike and Attorney Karen. And it's an honor to be here at ABOGADO.
All the pleasure is all ours. Now, let's begin with the basics. How strong is the presumption of truth in birth certificates?
That's a good question, Attorney Mike. Birth certificates are actually public records, and they enjoy the presumption of regularity and authenticity. And this is not something that we just made up, but this is according to Article 410 of the Civil Code and Act 3753. That's why people can have faith in these public documents. So when I show my birth certificate and it says my mother is, shout out to my mom, Fatima Jumrani, and my dad is Marjuk Jumrani, so the world can rely on that statement in my birth certificate.
Okay, and I think, partner, this is such a relevant discussion because
Indeed,
like, marami na ngayon sa panahon natin, one, relevant siya because if you are an illegitimate child, but you are recognized by your biological father, then you do have inheritance rights as with regards to your dad, right?
Yes.
Kalahati lang siya ng legitimate child, but still, you enjoy that presumption na may entitled ka sa pagmana.
Right.
But right now, also relevant because marami nang surrogate ng babies, right? Kahit sa abroad nila gagawin, tapos iuwi dito. So, let's say nagkaroon ng succession and you have a same-sex couple, tapos meron silang anak. Yung mga kapatid would have the right to inherit if walang ibang anak, no? So, they can ask for, let's say, a paternity test and say na hindi naman namin, hindi kaano-ano yan ng kapatid namin. Therefore, kami dapat yung magmana. So, ganun pala pag let's say nasa birth certificate, kahit na kini-question ng pamilya na baka illegitimate or hindi nila biologically kamag-anak, then the birth certificate prevail.
Correct, correct. Let me just state that indeed, while a birth certificate is a public document and the public can have faith on the document, let's remember that it only gives a prima facie evidence of the truth of the truth of the facts stated therein.
So rebuttable.
And when you say,
It's
yes,
rebuttable.
it's rebuttable. Ang pinakasimpleng expression siguro ng prima facie is true at first glance. So that's why if there are circumstances or evidence to rebut the facts stated therein, then if these facts are established, then that birth certificate can be disregarded and maybe even canceled. So the public need not rely on that. And let's remind ourselves na in the past year, naging questionable ang mga records sa civil registry because of, the Alice Guo case, Chinese getting birth certificates in the provinces and all that. So these instances actually expose the vulnerability of our civil registry records.
Well, based on science, should
Yes.
courts ever allow DNA tests to overturn what is in the birth certificate?
That's a good question because with the advances in DNA technology has already been used to both prove and disprove paternity and filiation. It's almost 99.9% accurate. DNA testing has been used for, not just in paternity and filiation cases, but also even criminal cases. Like, for example, if there is a need to identify the remains of, let's say, a victim of a serious crime, or perhaps to determine the presence of the accused in the crime scene, DNA testing can be relied upon. But most importantly, in paternity and filiation. And it has been used as evidence in cases like support. Like when a mother tries to demand support for an illegitimate child, the father can demand a DNA testing to disprove that that is his son. And similarly, in inheritance cases, like what you said, let's say you have collateral relatives, a person dies, and the collateral relatives, these are the brothers, the cousins, and even the children of these brothers and cousins, expected that they will be the ones to inherit, and then suddenly someone
appears.
Appears and says, ako ang totoong anak. Ako ang totoong madrigal or something like that.
Pwedeng plot sa sine.
Exactly.
Yeah. But it really happens in real life,
Yes,
no?
exactly. And so DNA testing can also be requested to determine the paternity and filiation, but it's not that easy.
So Attorney Al, what standard of proof should courts require before actually ordering DNA testings in, for example, in inheritance cases?
Yes, okay. Now, DNA testing is, as it is already an evidence or proof of a fact. So it may prove a fact or it may disprove a fact. However, we must remember that DNA testing or the request for DNA testing is not easily availed or is not easily issued. Because as ruled by the Supreme Court, for example, in the case of Lucas versus Lucas, the Supreme Court held that a party seeking to avail DNA testing must first present prima facie evidence or establish good cause for the holding or requesting of the test. So for example, if it's paternity and filiation, you don't just say, I feel, or yung lukso ng dugo ko dito sa isang tao na to, so I want to request for a DNA testing. No, you have to establish to the court na meron akong relationship sa nanay nito. Okay? That we had a relationship, romantic and intimate relationship, so this child could be mine. Or similarly, let's say a child would like to establish his or her paternity with a certain man na sasabihin muna niya na when my mom was, let's say, this 9 months ago or 10 months ago, my mom had a relationship with this guy. So I'd like to request for DNA testing to establish that paternity.
And once
Can he be
that is
compelled?
requested from the
Diba?
court, yun na yung
Yes.
same
Diba?
question
Diba,
tayo.
partner?
So,
Can he be
pagka
compelled?
request mo sa court and may grounds,
Yes.
and the court orders it,
Yes.
Yeah.
mandatory na yun. You can be compelled.
Mandatory,
Ah.
exactly.
Hindi ba violation of your privacy rights?
Okay.
Or
All right. Let's explain that because that has been a common question.
Yes.
Pwede ko bang tanggihan yung DNA testing? Well, number one, we have to give it to the court that the court will be the first person or the first entity to protect your rights. So the court will first decide whether the request is justified. So if you have grounds to oppose it, like that's impossible. I had no personal relation. I haven't known the mother of this child. Then the court will entertain your grounds.
So grounds mo, in a sense, you could say it's circumstantial.
Yes, it's
Diba?
circumstantial,
Pardon?
it's
Yeah.
preposterous, so
Oh.
you can refuse it. And so the court may deny the request. But if the court grants the request, it's because there was a basis for the request. And if this request is granted, the order is final and executory.
Which
So
means
it
then
is
you can
not
be compelled.
appealable. You
Yeah.
can be compelled. If you don't comply, you can be cited in contempt.
Final and executory at the level of the
Yes.
regional trial courts.
Yes,
But
yes,
then,
yes.
pagka grave abuse of discretion, dun ka lang pwede
Not
umakyat sa
even.
Supreme Court.
Not even.
It's
Wala
so-
rin as certiorari under the
Talaga,
rules of
hindi
DNA.
available
Yes,
doon.
kailangan talaga. Because
Okay.
again, okay, let me just share yung sinasabi ng rules. No? Other...
Sorry, nakabahan ka yata.
Oo.
Ikaw, a partner. Why am I
Kasi meron,
looking at your eyes and
okay.
seeing a bit of worry? I'm just kidding.
Okay, ito, finally I found it. But take note that under Section 5 of the Rule on DNA Evidence, the grant of DNA testing application shall not be construed as an admission into evidence of any component of the DNA evidence that may be obtained as a result thereof. So we
Okay.
need to say, okay, makukuha siya ng DNA evidence from you, but it's not an admission automatic. It doesn't mean that, ikaw na talaga ang tatay.
You have to, it has to be proven pa rin.
Yes, it has to be proven pa
And-
din.
Interesting, but you said, di ba, 99.9%
Yes, 99%.
accuracy
Yes,
ang DNA
yes,
test.
yes,
So for
yes.
example, I'm someone who wants to establish that a person is my dad.
Yes.
Tapos, na-compel ko siya through a court order. And it comes out as positive.
Positive.
But I can't use it as evidence to
No,
establish that
it's
this
not-
person is really my father.
It's not automatic. So
Ano yung
you still
process
have
mo
to
pa?
establish the relevance of the DNA testing to the issue at hand. So remember, there are guidelines, and these guidelines are also found in the rules on DNA evidence under Section 4. Okay, and particularly the pinaka-importante na guidelines dyan is the guideline number 1, which says a biological sample exists that is relevant to the case. So if it's not relevant to the case, even if there is a match, it will not be considered. Okay, number 2, and which is number 4 in the guidelines, the testing has the scientific potential to produce new information. And this new information is relevant to the proper resolution of the case.
Okay.
So you could be a positive match, but if it does not produce any relevant or new information, it could be disregarded.
Depending on what's filed in court, right? So,
Exactly.
but eventually, if you file like a claim and there's an existing estate proceeding,
Yes.
Yes.
then I can present that as evidence in the estate
Yes,
proceeding.
because it is very relevant, especially to establish successional
Oo,
rights.
sa paghabol mo sa mana.
Yes,
Okay.
correct. Kasi sa batas ng succession,
Yeah.
dugo ang basehan.
Correct.
Diba? And also adoption.
Yes, yes.
Yeah.
Of course.
And we all know naman that the technology, the science through the years have really improved.
Yes.
It's really so accurate now. In fact, di ba, alam natin that some people who were found guilty in the past, when there was no DNA testing,
Yes.
then were eventually acquitted. di ba,
Yes,
because
post-conviction. Yes,
post-conviction,
because
no? But just to make a quick comment, I think one of the reasons, partner, sa aking pananaw, kaya they made it non-appealable, is because if you delay this, as lawyers, we have ways of prolonging a case. Di ba? We can file appeal, petitions, motions, etc., all the way up to the Supreme Court.
Yes.
And sometimes in the Supreme Court, it could stay there for years. No? So, kaya siguro talagang gusto nilang doon pa lang RTC tapos na wala ng appeal. Dahil nga, ang nakabinbin dito, what is at stake is not only the filiation of the child or of the person, but also the inheritance rights and
Yeah,
the property
that's true.
rights. No? So ang implications marami. So it will be held in abeyance kung hindi magkakaroon ng closing.
That's
Would that be a correct?
Yes, that's
Yeah,
correct.
yeah.
Especially since these are supposed to be matters that must be resolved in an expeditious manner, particularly yung inheritance na yan. And I think the case, which is the reason why we're discussing this, involves the inheritance or the estate, which composed of properties, bank accounts, and other intangible properties.
Yeah,
And
oo.
yet, na-distribute na yung mga
Oo,
properties.
at nagastos na nung
Nagastos na.
yung mga nagkiklaim na heirs.
Alam mo, partner, ito, not for anything, tongue-in-cheek. Ito relevant lang to pag maraming paghatian.
Exactly.
Kung talagang
sabagay.
marami kang properties, yan, this is
Correct.
but at the end of the day, kung there's not too much, like ako, wala naman akong in-inherit. So, there's never an issue.
Kaya kapag mga gay away-away tungkol sa succession and inheritance, tagang reaction ng marami, buti pa sila, meron sila.
Oo nga, no, sabagay.
Pag meron sila pinag-aagawan, meron sila
Yeah.
paghahatian.
But you know, this is also relevant for crimes. Like for
Yes.
example, an allegation of rape, and then
Yes.
nagde-deny yung
Yes.
lalaki na we never had any intercourse, and then later yung bata na pinanganak,
Correct.
positive pala sa DNA nung
Yes,
accused,
yes,
right? Then
yes.
you can either reopen the case in light of new evidence, or you can
True.
present it
Yes.
there.
Remember, because DNA is very microscopic, it can be taken from hair follicles or even like remains, fluid remains.
Usually, they swab you, di ba?
Yes, exactly.
Well, is circumstantial evidence, like, unusual family circumstances, enough? Or must there always be a direct evidence of fraud or falsification? For example, yung sa birth certificate nakalagay na pangalan is a child that was the result of surrogacy. So let's say yung donor or yung dad says na anak ko talaga to, pero nag-hire sila ng surrogate from abroad.
Yeah.
And then something happened to that dad, and syempre dito wala rin tayong same-sex marriage, so maghahabol yung mga kapatid naman nito or yung pamilya nung, let's say, the one who passed away. Would there unusual circumstances, the fact that it's a same-sex couple and then yung anak is from a surrogacy, be sufficient for the court to say that, yes, there should be DNA testing, and would that override what is in the birth certificate? Meaning yung intent ba nung tatay na doon niya gusto ipamana doon sa taong kinoconsider niya na anak niya?
Okay. Well, first, ang topic ng surrogacy is very complex. Una-una, kasi we don't have a law on surrogacy. So this surrogacy must have been made abroad. And if it is valid there, then the birth certificate of that child should be considered valid here in the Philippines. However, if there are evidence showing that this child was not the product of the sperm of the supposed father, kasi syempre pag surrogacy talaga ang nanay niyan is the surrogate. Pero kapag hindi niya sperm yon, ibig sabihin ang nag-fertilize ng ano na yon, that allegation can be proved through DNA testing. So you have to first establish the circumstantial evidence. And under our family code, we have 3 recognized circumstantial evidence to negate or to deny blood relationship, meaning to see the relationship of the father and the child. Number 1, physical impossibility of sexual intercourse. So physical impossibility of the father and the surrogate mother to have sexual intercourse. Second, sterility or medical condition preventing the husband to impregnate another person. And also other evidence showing that it was not possible that this child is the child of this father. So with this circumstantial evidence being established, then you can request for a DNA testing. And the DNA testing will then supplement the circumstantial evidence. That's actually very weird here, because the Supreme Court has held you have to first convince us by this circumstantial evidence before we can grant you the DNA testing. It's not the other way around. I will request for a DNA testing and I will prove to you that it was impossible for this child to be his or to be mine. First, I have to establish na imposible mag-ianak ko yan, and I will prove it to you through DNA testing. Ganun
Interesting.
ang
So kung ganun pala, yung mga kapatid will also have a hard time
Exactly.
requesting for a DNA test. Eh,
Exactly.
paano, teka
Yes.
lang, kung nag-pass away na, saan sila
Yes.
kukuha ng DNA?
Okay, ito. Doon sa case na Aquino versus Aquino, which is a 2021 case, the Supreme Court said na hindi kailangan exclusively DNA from the father. Kasi yung mga genetic makeup ng father, makukuha doon sa mga kapatid. Yes. So for example, may mga kapatid, sasabihin nila na they are able to show that this child is not the child of our kuya. Okay? Kaso patay na yung kuya. If the court agrees with the circumstantial evidence and allows the DNA testing, yung samples mo ang kukunin. Kayo magkakapatid, saka sample yung itong bata.
Interesting.
Yes.
Oo. Kaya, and then from there,
Yes.
that will override. Let's say na-prove nga na hindi
Correct.
pala anak
Correct.
yun ng kapatid
Yes.
nila. They can override yung
Yes.
decision ng kapatid nila to treat that child
Correct.
as
And that birth
child.
certificate
Parang
can be
pwede nilang
cancelled.
kunin yung mana and
Correct.
hindi na,
Yes.
hindi na magmamana yung
Yes.
bata.
And remember, we have what we call simulation of birth certificates. And DNA testing can establish simulation. And if that birth certificate is established to be simulated, then that birth certificate cannot be relied upon.
Wow. So,
ano
ibig
mangyayari?
sabihin yung mga nagpaampon tapos nagsisi later on. But let's say, ako, I gave up my baby. So,
Yes.
merong couple na umampon.
Yes.
Tapos, sinimulate lang yung birth certificate. Meaning, pinalabas doon na sila yung parents.
Yes.
And then, years later, nagbago isip ko, gusto ko nang bawiin yung anak ko. And then, I can prove by DNA testing na that's really my child. Mababawi ko yun. And they can cancel the birth certificate.
Correct, yes.
Yung cancellation ng birth certificate, you still have to go to a proceeding.
Yes, yes. We have to emphasize that while we are entertaining, and we can in fact entertain these possible scenarios
Yes.
that birth certificates are false, remember that the Civil Code, I think it's under Article 412 of the Civil Code, says that no birth certificate, no record in the civil registry can be cancelled or corrected without judicial order. So that's why malakas ang loob ni Alice Guo dati.
Yes.
I have a
Yes.
birth certificate.
Yes.
Wala po akong kinalaman sa paggawa niyan. So
Lahat naman ng mga
Yes.
without mentioning the name na
Yes.
lang, kasi kaibigan ko, there was recently a Chinese businessman, a prominent Chinese businessman,
Correct.
na sinabi daw na late yung application niya for birth certificate similar to Alice Go, kaya question. No?
Yes,
But,
correct.
yeah, well, that's another story altogether, maybe another legal issue, but the fact of the matter is, nagkaroon siya ng passport, no? And it was Filipino. But just to go back a bit on the birth certificate, so, in a sense, partner yung birth certificate, parang ano yan, land title, yung deed.
Yes,
no?
exactly.
Diba,
We should take it on its face
diba?
value.
Yes,
We were
correct.
taught in law school
Yes.
that a buyer, in good faith, can rely on the four corners
Exactly.
of the TCT, or the original certificate of
for-
title.
yeah.
No?
Yes.
But of course, it can be eventually impugned if there is fraud or whatever.
That's right.
So in a way, pareho ba sila?
Parehas, exactly.
Okay.
Ang torrents title lang ay
Yes.
record ng ownership of property, land especially. But remember, it's merely evidence of ownership. If that ownership does not exist, or if the person named in the registered, the registered owner in the title is not really the owner, then he cannot be protected by the torrents title. Similarly, the birth certificate. The birth certificate is only evidence or only a statement of the facts stated therein, and it enjoys the presumption of regularity. However, if those facts are false, then you cannot be protected by that certificate, by that birth certificate. But then again, just like in torrents titles, it will require a long process, a court process, in order to disregard the effects of a birth certificate.
Now, partner, maybe we should also ask, no, yung mga judges,
Yes.
do they have broad discretion to permit or deny DNA tests in, for example, estate cases, or should clear statutory guidelines be set?
Okay, I'll first answer the question on discretion.
Yes.
Okay. Judges indeed exercise discretion in granting the request. However, this discretion is also guided by the guidelines under the rules on DNA evidence. So, as I've mentioned earlier, there are guidelines, foremost of which are, number one, relevancy, or materiality of the request, and also there should be new information that can be established, and this new information can affect the resolution of the case. If we can discuss the case of the Direk Guenderamas, the request was grounded on sexual orientation. That allegedly, Direk Guenderamas could not have sired these children because he was a homosexual. And, you know, anyone can tell you that that's a very weak justification. And so the regional trial court denied the motion. And then the siblings went to the Court of Appeals assailing the decision which denied the request. And what do you expect? Of course, the Court of Appeals affirmed the regional trial court, saying that the justification was wrong. You cannot request for a DNA test on the simple ground that a homosexual could not have sired a child.
Interesting. So right now, based on that court ruling, the prevailing doctrine is that homosexuality by itself is not circumstantial evidence that would justify mandating a DNA test.
That's right. Because as I have mentioned earlier, the circumstantial evidence here must relate to the impossibility of siring or fathering the child, such as physical impossibility,
so
medical
sterility,
illness.
more like that.
Sterility. Pero nung ang request nila dahil bading daw si Direk Guenderamas, talaga hindi ho pwede. Kasi that does not negate, that is not equivalent to impossibility. So they had to maybe change strategy and give another reason to request for
or
DNA
erectile
testing.
dysfunction, diba?
Yeah.
So you rely on medical records.
Just as a joke, meron
Correct,
nga dati, di ba, kinasuhan ng rape. Tapos sabi niya, Your Honor, sabi ng abogado ng defendant, no? Sabi na sa accused, impossible my client would commit rape because he has a dead weapon.
Dead weapon, not deadly
Akala ko
weapon.
may kadugtong yung joke. Nasasabihin na lang ng client, no, I committed the rape. Para hindi mapahiya. Okay. But based on the fact that there's discretion, sorry, is there something you wanted to add?
Please.
I am actually excited for the next question because you're talking about this
Considering
discretion.
they may discretion yung mga judges based on past rulings, has the court been consistent or do you see some kind of back and forth sometimes na nag-iiba-iba?
Nag-iiba-iba. In fact, pati ang Supreme Court nag-iiba-iba.
Okay.
Like,
So
for
para
example,
pa lang itong yung mga iba rin na court rulings on, yung recently sa COMELEC on whether yung number
yung
two,
number two.
is the
Yes,
winner, yung
exactly.
second placer rule. Okay.
Kumbaga yung loser doctrine ba yan? Kaya, anyway.
Marami namang ganun nag-iiba-iba, depende. Sa Amerika nga, Roe versus Wade,
Yeah,
diba?
because you still have individuals exercising discretion, which is why relevant yung tanong mo, dapat ba magka-statutory guidelines or should we leave it up to discretion?
Yes,
So ano
correct.
yung mga nag-iba-iba over
For
sa ibang
example,
decisions?
pagdating sa DNA testing, again, as I said, yung sa paternity and filiation, that has been used or accepted to establish paternity and filiation. So, what we said, automatic ang court check. If you want to establish paternity and filiation, DNA testing will be granted by showing that the child has been treated as a natural child since childhood, kaya for several years, kaya so i-confirm na lang natin. Pero pag gusto mo i-disprove ang paternity and filiation, ngayon, mas mahirap mag-request ng DNA testing because may birth certificate ka. Ayun.
So that helps, the birth certificate helps.
Correct.
Yes.
So kaya ang inconsistency is, yun na nga, what are you requesting? What are you trying to prove? Now, of course, meron ding inconsistency sa anong remedy ang final mo. Because for example, if you file a remedy for say, recovery of ownership of property, like saying that this property was transmitted to them on the ground that they were alleged children, but they were not. So kami ito ngayong real heirs, so we are filing this case to recover that property. Baka hindi yan tatanggapin yung request mo for DNA testing just to prove that they are not the owners. Because the Supreme Court has ruled that you have to file a direct action against the filiation of the child rather than raising it as an issue in a separate case. So, sabi naman ng Supreme Court, then you file an action to impugn legitimacy or filiation under Article 170 and 171 of the Family Code. Eh, sino lang pwede mag-file nun? Yung tatay ng bata.
So hindi pwede.
Hindi pwede ibang tao.
Indirect, parang collateral attack yung tawag nila, di ba?
Yes, hindi
So, hindi pwede
Hindi
na
pwede.
yung mga
Dapat
kamag-anak.
yung concern na nandun sa birth certificate, like kung sino apektado, obviously, the father. Kasi yung mother, kasi hindi mo pwede i-deny na sa'yo yan kung sa'yo talaga nang galing yan. Diba? You can't say na, that's not my child, nagkaroon na substitution. Look at the
Paano kung
color.
surrogate lang yung mommy? Pwede ba yun?
So, surrogate ang mother. Kasi ang surrogate kasi, wala man nasa ibang bansa
Oo nga, wala kasi tayong law on that.
yeah,
So
wala
sa
kasi.
atin,
Sa
as
atin
far as the
talaga,
law is
yes.
concerned, pag ikaw yung nanganak, you're the mother.
Yes, you are the mother. So yung tatay ngayon, siya kasi yung interested party to question the filiation. So kaya, pagka hindi siya nag-file ng action, ay wala na. No one can raise that question.
Interesting. So I guess in the end, if this is a state proceeding
Yes.
where the siblings of a father who passed away
Yes.
are questioning the affiliation or yung filiation
Yeah.
nung batang naiwan, nung deceased,
Yes.
nung namatay na tatay, they cannot
Okay.
attack. Or,
Ayoko kasi magbigay ng unsolicited advice. Okay. Kasi ganito nakikita ko dyan, no? They had to recalibrate the question or the issue. Kasi they were trying to say, kasi hindi po pwede anak yan dahil bakla yung kapatid namin. Okay? What they should say or what they should argue is that there is evidence showing that this child was not born kasi nga someone else was yung parents, establish nila kung sino yung mga totoong magulang ng bata para to show that this child was never his and that this birth certificate is a simulated birth certificate. And if they can show that, okay, ang atake kayo is yung birth certificate, hindi na yung filiation. Kasi kapag ka-filiation, again, the remedy is Article 170 to 171. But remember, the father is already dead. So he's the only one who can initiate that action. So atake mo dito ka sa birth certificate.
so kung nakikinig pala yung mga involved in
Yeah.
a recent, in a case that's still pending in court right now.
Correct.
Ito yung free legal advice.
Free legal advice. Abogado can charge them later on.
Yes, of course.
Attorney Al, what happens if, for example, we did touch on it earlier, but what if the heirs, as I mentioned, no, sabi mo, they can be compelled. But what happens, for example, if they refuse? Is there does this somehow create a presumption against them?
Oo,
Alright.
good question. No? Kasi kayo pwede mo sabihin, kung totoong anak ka ng kapatid namin, then submit yourself to DNA testing and that solves
The
problem.
problem.
All right. Okay, get yan.
And that can be used, that presumption against you.
For the children, okay, if they refuse to submit to DNA testing, and assuming the court will agree, okay, you will not be compelled to undergo DNA testing, walang mawawala sa kanila because they already have the birth certificate.
Okay.
Yan. But this will only mean that the other side or the other parties will have to look for other evidence and other basis for showing that this birth certificate is simulated. Yeah. Because, well, unfortunately, we cannot apply here. Yung meron tayong principle kasi or doctrine in the rule of evidence that evidence, if suppressed, is presumed to be adversarial or that it is an
Against your
evidence
interest. Yeah.
against the interest of the person.
Yeah.
Pero hindi, pagka ni-refuse yung DNA testing, the result would not be adverse. Kasi nga, meron ng malakas na ebidensya in their favor ito sa mga bata ito, which is the birth certificate. So they have to calibrate and look for other reasons why the DNA testing can be justified. Yeah.
Well, if the court, for example, makes it easier, or if the statutory guidelines make it easier to ask for DNA tests, do you think this will open the floodgates
Ayan.
to challenging birth records which enjoy the presumption of regularity?
Yeah. I don't think that if courts will be more lenient and will easily grant these requests, that there will be a surge of cases challenging birth certificates. I don't think so, because as I have said earlier, there has to be the sequence of events should be first, there's a reason to question the birth certificate, followed by DNA testing. So remember, birth certificates are, as a rule, the result of reports from mothers, from relatives, from fathers. It's a very familial thing. So hindi mo masyado hindi agad kino-question yan. So people will still rely on birth certificates. In fact, ngayon, napakabilis nga makakuha ng birth. Say, children are born usually in hospitals, and hospitals follow very strict guidelines in reporting these children or the births of these children to the civil registry. So naiiwasan yung mga possible fictitious birth certificates. So I don't think na kahit maging lenient tayo na people will, start questioning their birth certificates. But at least nandiyan pa rin yung option, because indeed we still have this grave concern of birth certificates being simulated. Yes.
Yeah.
Now, Attorney Al, if example, adoption was only informal and not judicially decreed, no?
Yes.
What is the standing of children listed in these birth certificates?
Well, if, number one, if they are only informally adopted, meaning to say, not through a judicial decree.
Yes.
At tatawag natin informally mga ampon.
Wala sa adoption law, hindi sumunod sa adoption law.
Correct. Wala sa adoption law. If they are just informally adopted, maybe they are just foster kids, they don't have rights of inheritance, because the right to inherit is reserved to blood relatives and those that are judicially or officially adopted, because now adoption is already administrative.
Yes.
So there must be either blood relationship or the relationship is by law through adoption. But again, yun na nga, knowing that nandyan yung dalawang options para makapag-inherit by blood and by adoption. Pag hindi dumaan sa adoption, so wala mong by blood, so isimulate natin ang birth certificate. So yung mga children who have these simulated birth certificates will have better rights over other relatives. Because remember, under the law of succession, the children or the descendants exclude the ascendants and the collateral relatives.
Yeah, oo. So, pagka simulated birth certificate, kahit hindi kaano-ano nung parents or whoever the parents are that passed away, pwede talaga sila mag-inherit unless someone is able to prove na simulated lang yung birth.
Yes.
Okay. Well, super interesting, partner, and very relevant to so many scenarios here in the Philippines. But we'll have to pause for a quick break. Our discussion on DNA testing and inheritance disputes with attorney Aliakhbar Jumrani continues. This is Abogado.
Welcome back and thanks for joining us. This is Abogado. Before the break, we explored the tension between the presumption of truth in birth records and calls for DNA testing in inheritance disputes.
Now, Attorney Al, we'd like to hear your closing thoughts on two key points.
Okay.
At the end of the day, how do we balance the anger of relatives or the demand for fairness with safeguards of the Constitution so that accountability does not come at the cost or expense of rights? I guess kasi yung sinabi mo nga kanina, di ba, na pagka simulation of birth and hindi na disprove yun, then someone who is not a blood relative will enjoy better rights than yung ascendants, meaning either yung lolo't lola na totoong kadugo nung namatay and
Or
yung
yung
mga
mga
kapatid.
kapatid.
Oh.
All right. So on that, of course, we have to remember that the law reserves the estate for certain persons. And these persons are, as I've mentioned earlier, they are the children or descendants, and then you have ascendants, collateral relatives, and of course the spouse, okay, if there's a spouse. Now, the law reserves to these persons the estate because the law presumes that these are the people that the deceased wanted to leave his properties to. Meaning to say, pinipresume yung wish nung namatay. Now, so even a collateral relative can say that I am entitled because the law says, minahal kami at we expect that we are entitled to a share. So because of this, we have to safeguard their rights. Okay? And I think the height of injustice is for people who do not deserve to receive will deprive those who deserve to receive. And so we have to balance the law protecting these rights and also the law protecting or preserving these documents. And by reason of these documents, they are able to demand these rights, if you know what I mean, yung mga children. Okay, but remember, we are treading on very, very delicate grounds here because we also have to remember that children cannot be exposed to this, very, horrible and very traumatic experience of their identity and of their status being questioned.
That's a very good point. Kasi what if they really grew up believing that these are their parents and kaya nga sinimulate yung birth because the parents also want their child to experience that feeling na anak talaga namin, ikaw, di ba?
Correct. Tapos ganun, no? Tapos I mean, what happens to them? They would now be parang mga stateless persons, so to speak. Pero ito more like identity-less persons. Okay. But since you mentioned simulation of birth, and we have been discussing simulated births, remember last 2019, Congress passed Republic Act 11222, which rectifies simulated births and facilitate the adoption of these children. So if a birth certificate is simulated, and the reason for simulation is to give these children a better life or a better future, all it takes is to admit to that simulation, magiging immune ka na from criminal liability, and then these children will now be adopted. So, ang mangyayari, yung simulated birth certificate na yun will be canceled and an adoption certificate will be issued. So, kaya let's say, ganun nga, no, doon sa itong hypothetical case natin na, let's say, kinwestiyon ng mga kapatid yung birth certificate because simulated yan. Alam mo what can further prevent, and this is something they should also consider, what can further prevent their remedy is that when these children apply for the benefits of Republic Act 11222, they will say, okay, we admit, okay, we will not deny that our birth certificate was simulated or were simulated kasi dalawa sila dyan eh. But we can all agree that our father adopted us at a young age to give us a better future. So pag yun ang naging argument talaga, automatic under the law, their birth certificate will be cancelled at magiging adopted sila. And
so
if
therefore,
they
all
are
the rights
adopted,
of an adopted will vest, which means they can inherit.
Then they can still inherit. Kaya nga talaga they have to consider talaga kung ano ang strategy nila. Kasi either way, if they challenge the birth certificate as being simulated and they will avail of Republic Act 11222, magiging adopted child sila. Oo. But then, ito, dagdag ko lang din, under the law, 10 years lang yung benefit o yung proseso na yan.
From the time of
2019.
birth or from the time?
No, from
2019.
Yes.
Okay.
Yes,
So malapit
because-
na mag-close yung window na yun.
Correct, malapit na mag-close yung window. So kaya talaga, if you are watching, both of you, both
Yung mga
sides,
dun for the existing case.
Exactly.
O, ayaw pa natin sabihin kung anong case to kasi baka sabihin
mahirap na baka kasi
sub-judice. Oo.
sub-judice.
Yeah.
I'm glad to hear about that law. That's the first time I heard about
Correct.
that.
Kaya nga
RA,
sabi ko, kaya iisip ko, they have to really consider, mamaya baka mali atake nila. Tapos ito, isa kabila, sabi niya, okay, sige, fine. We admit our birth certificate was simulated.
Yes.
And then we
But
will,
can you make that admission? Let's say kung mag-prevail na yung pagkuha ng DNA
Yes,
test.
correct. Exactly.
So,
Pwede.
pwede rin.
Pwede,
So, let's
pwede.
say,
Okay.
lumabas yung DNA test.
Oo.
Hindi ka talaga namin
Hindi ka talaga
kamag-anak.
anak. Okay.
Oo. So, simulated yung birth
that was
certificate
simulated
mo.
birth.
They can take that path.
Yes, they
to
can take
say,
that
okay,
path.
fine, and then we avail of the benefits of this
And
law.
then we will avail.
Okay, so marami palang
May
advantages.
advantages din. I guess that RA took into consideration siguro the realities.
Or
di
the
ba?
intention of the
the
parents. Kasi
intention
if
of
you really
parents,
take
di
care
ba?
of someone, for you to go to that
Di ba?
extent na mag-simulate ka ng birth
Talagang
certificate,
gusto
gusto
mo
mo
sila.
talaga
Oo.
na
Kaya-
sabihin anak mo yun, no?
Kaya sabi nga ni, di ba, was it Oliver Wendell Holmes himself, the life of the law has not been logic but experience, di ba?
Exactly.
And dito nakikita natin, ang batas, tinitignan yung experience. Ang pagmamahal ng parents sa kanilang anak, ng mga magulang, at talagang ginawa na nila, they simulated na lang, para lang talagang masabi nila, anak namin to, at kung ano man ang nasa amin, pwede namin pamana sa kanila. Kaya, I'm glad, partner, and I'm glad to be educated tonight on this particular law.
I learned so much.
I was not aware of that law.
I have a last question, and this is
yes.
medyo kakaibang topic naman. Kasi naging big issue yung kay Senator Grace po when she ran for
yes.
the fact that she was a founding.
Yes.
So sinabi, baka hindi siya natural-born citizenship, citizen, that was a question about her qualification to become president. Let's say in-adopt, does that give the child, the founding, the benefit of being considered a natural-born Filipino citizen if yung nag-simulate ng birth certificate or yung nag-consider na anak nila yon are both Filipino citizens?
Well, una-una, dapat ma-establish mo natin na talaga foundling siya. Kasi kung hindi naman siya foundling, halimbawa talagang pinanganak siya sa ibang bansa, dinala sa Pilipinas, tapos kinunan ng birth certificate. So, hindi siya makukonsider as natural-born Filipino.
So may circumstantial pa rin, not just parang hindi pumapasa yung benefit of the citizenship of the parents that adopted or simulated the birth certificate.
Yes, correct. Now, yung pag-foundling ka talaga, as stated in that decision of the Supreme Court and also under the Foundling Act, which is sponsored by Senator Grace po, that means your parentage cannot be established at all. Pagka ganon, you are now presumed natural-born Filipino if dito ka nakita sa Philippines.
Very interesting. Ang dami ko talaga natutunan
Automatic
today.
na siya. Tapos automatic din, a foundling is now available for adoption. So, hindi na kailangan dumaan sa kung ano ang proseso. Basta pag-foundling yan, pagka-foundling ang bata, then it can already be adopted. So, pwede na siya ipa-adopt na, hindi na kailangan ng proof of abandonment. Kasi
shorter na yung process.
Kasi how can you prove that this child was abandoned, di ba? Yung mga ibalik. Kasi pag sabi mo abandoned, kailangan meron munang parent, tapos iniwan somewhere. But this is a foundling na hindi mo mahanap ang parent. So automatic available na for adoption yan.
Okay.
And natural-born Filipino, pwede nang tumakbong presidente yan.
Okay, interesting, no? Thank you so much,
Thank you.
Attorney Aliakhbar Jumrani. Thank you for joining us tonight and sharing your expertise on this very complex and sensitive issue.
You know, partner, Attorney Al, tonight's discussion reminds us that the law is not only about birth certificates and DNA evidence, but also about fairness, dignity, and, of course, the stability of families.
And as the debate on DNA testing and inheritance disputes continues, we must remain vigilant, protecting children's rights while preserving the certainty and integrity of our public records. This is Abogado.
Good night.